So as I indicate, we now hear evidence from Deborah Coles, Executive Director at INQUEST, and Professor Julia Walters, Minister.
Thank you, Chair. I have no questions. I'd rather allow, because we're short on time, other members of the committee to ask questions.
Okay.
I'm Kieran Mullen, I'm the Shadow Minister. Thank you both for coming along today and assisting us with our proceedings. I had a question for you, Deborah, in relation to the work of INQUEST. I just wonder if you could illustrate to us what the practical effect can be at inquests of having the public bodies, usually quite heavily legally represented, and affected families not having necessarily any legal representation.
Thank you for the question. I mean, it's been a long-standing campaign of ours to try and, sort out what we perceive as a real inequality of arms. I think the best way to describe it is that it's a traumatic and distressing process to go through an inquest into the death of your loved one in any event. But to try and navigate those processes without your own individual legal representation, and either be expected to ask questions yourself or rely on the coroner to do so on your behalf, I think is not only extremely unfair, but I think perpetuates that sense that the system is not working to get to the truth and to deliver the answers that you want as a bereaved person about how your loved one died. And I mean, I can think of so many examples since INQUEST was set up where families and still today are talking about the re-traumatizing nature of the inquest process. And I think what legal representation can do as well is it can enhance the really important preventative function that an inquest can play in safeguarding lives in the future. But that is only where you have a family with the benefit of a lawyer to explore the areas of concern. And in our experience, too often, the default of state and corporate lawyers is to try and defend their reputations, to try and narrow the scope of the inquest process, to try and prevent the very serious issues that need exploring, particularly when we're talking here about our work is predominantly around state-related deaths, so where the state had a duty of care towards somebody. And, I think in our experience, it's only through legal representation and where families feel that they can play a meaningful and effective part in that process that the truth can come out.
Okay. And you've mentioned coroners there and what the coroners might choose to ask or not ask. What's your experience of the variability in the way in which coroners approach these issues?
I mean, I think, there's a lot to be said about the inconsistency of the coronial system and different coroners approach their roles in very, very different ways. But I think it's actually quite hard for an individual coroner when they are confronted with teams of state lawyers representing different interests to then try and properly represent the interests of an individual family. Some coroners can try and do that, but I mean that doesn't take away from the fact that it is the relationship that the bereaved family have with their lawyer that can often ensure that the questions of the utmost importance to a bereaved family are actually asked.
And some questions to you, Professor Waters. First, I just want to acknowledge the circumstances that bring you here today, and not something that any of us would want to experience. Condolences on your loss. What was your experience of applying for legal aid, and what difference did it make to you? That my understanding is you didn't get representation.
Well, if I can just sort of start by saying it was 2 years ago, exactly on this day, that the inquest into my sister's death started. And we found out 4 days before the commencement of the inquest that our application for legal aid had been refused. 4 days. So in preparation for that, for the possibility that we might either have to go into the inquest not represented, or foot the bill ourselves, or the lawyers have to do it pro bono, why should they? I did read over 2,000 pages of disclosure evidence myself, some of it very traumatic, as you can imagine, to read some of the details of what my sister went through and some of the medical reports and so on. You know, that alone was traumatizing. A Freedom of Information request recently found out that Ofsted, who were one of 3 public bodies, interested persons that our family were up against, spent £68,000 on external counsel alone and couldn't provide us with the figures for how much they had spent in their internal legal department. You know, Ofsted has its own legal department, but it still spent £68,000 of taxpayers' money on external counsel. Presumably, the other interested parties, Reading Borough Council and Berkshire NHS Trust, will have spent similar amounts of money, also have their own internal legal departments. So my family, as taxpayers, were indirectly paying the legal fees of the 3 bodies that who had done harm to my sister. So that just speaks volumes, I think, to the imbalance of power in this system. But if I may say as well, oh, sorry, it is just really re-traumatizing that at your absolute lowest, and I really hope no one in this room has been where I was, it's at that point that you suddenly have to navigate this entirely alien system. You don't have lessons at school on what is an inquest and where do you find an inquest lawyer and what's a prevention of future deaths report and what kind of coroner do you want to get, what kind of inquest are you going to get. But suddenly, when you're absolutely traumatized by a terrible preventable death of a loved one, you have to find this stuff out. And I would say that I am here speaking to you. You know, I've been speaking publicly about what our family has been through, continues to go through. But for every person like me, for the other witness you've heard here, how many hundreds of people are there who are just crushed by that system and who aren't able, for whatever quite legitimate reason, to stick up for themselves, to inform themselves? So I think parity of arms is absolutely crucial, absolutely crucial, and it can't come soon enough.
Okay, thank you.
Thank you. Tessamont.
Thank you, Mr. Dowd. I wish to make a declaration, and that is that I am a Vice Chair of and a Director of Whistleblowers UK. And I want to be really clear about that. That's a not-for-profit organisation. I receive no financial recompense for anything that I ever do. Thank you. I'm very sorry to hear what happened. Very sorry.
It's going on.
I know, and what is happening. And I salute your courage. Thank you both for saying what you said. Could I go in the direction, please, of whistleblowing, if that's possible? And to just ask you what you feel there might be in the way of protections within this scenario. What protection should there be for whistleblowers?
Could I go first? I mean, I can't. I'm speaking just from my own experience here, not as a lawyer or anything. But I have actually, in the last 3 years since Ruth's death, nearly 3 years, been contacted by various people within Ofsted sharing some really quite disturbing information about Ofsted's behaviour, about its rewarding of certain members of staff who were associated with Campbellshire Primary Inspection and other appalling cases, but when I have said, will you speak out, they said they daren't. They have to sign some form of the Official Secrets Act. I have been contacted by numerous head teachers who've been traumatised by Ofsted inspections, have lost their jobs, have lost their health, nearly lost their lives, and who haven't been able to speak out because they were made to sign NDAs in order to get some money to support their families. It just seems that at every level there are mechanisms put in place to do the absolute opposite of what inquests and inquiries should be doing, that there are mechanisms that are put in place that suppress legitimate concerns and defend people who are doing active and ongoing harm. So I think, yes, the stronger the defence, the protections there can be for whistleblowers, the better. And maybe, finally, all those people from Ofsted who have contacted me will be able to go public about the things they have told me.
Thank you.
I mean, the only thing I would just add to that is what we're talking about in the context of Hillsborough law is trying to effect legal, cultural and practical change. And I do think that if we can help rectify that kind of culture of cover up and obfuscation and denial and defensiveness that occurs when things go wrong, and I'm talking, we're talking across inquests, inquiries, other, not only when people have died, but other injustices. One would hope that this will help victims in the long term because, it will enable honesty and truth-telling, and hopefully that will permeate across the system and also to those who've got important evidence to contribute to inquiries and inquests.
And I just put it to you, the last point I would make. We've had the Nolan Principles of Public Life since the mid-1990s, 1995, I think. And if I was to pick out 4 of those 7, it would be integrity, openness, honesty, and accountability. Where are we now with this bill in comparison with that? What is going to change the culture?
May I again?
Yeah, you can.
I have actually written various messages recently to Martin Oliver, the Chief Inspector of Ofsted, quoting those Nolan Principles. I have received replies that apologise for his insensitivity and promising empathy. I haven't asked for empathy or a sensitivity or a performance of those. I've asked for honesty. And clearly it doesn't work. And I would say, also Ofsted have a code of conduct, which they kept quoting in the inquest, but what the coroner clearly found was that code of conduct didn't apply. So I think there's the Nolan Principles, there are codes of conduct, there are accountability hearings, there's even an offence of perjury, but none of them seem to work. I think they're too easy to slip away from. So I think, yes, a statutory duty of candour with the possibility of criminal sanctions, sadly, is what's needed. It beggars belief, but that is what's needed to make public bodies be honest.
I think that's the thing that people find quite shocking when we are talking about Hillsborough law, is that you have to effectively legislate to get people to tell the truth. And I support what you're saying about penalties, but it's also about monitoring and evaluation, because this Hillsborough law will only be as good as its implementation. And, as I said, up and down the country, there are families going through legal processes that are so defensive, so traumatising, that, the injustices that you heard expressed today by the Hillsborough families, and you'll hear more later, about the lying, the victim blaming, the delays, the denials, are still faced by families going through these processes today. And that is why this bill is so, so important.
Thank you. Thanks, sir.
Lizzie Collins, please.
Thank you, Chair.
This is likely to this is likely to be the last question, I'm afraid, on this.
Okay.
We might get a couple more in, but possibly.
I'll try and be quick, Chair.
So families have told me that they've experienced during coroner's inquests the following: information having to be dragged out of public bodies, hostile legal teams, and a process which is meant to be inquisitorial becoming adversarial. Do you have any comments on whether the measures on this bill will improve that situation?
I mean, the first thing to say is that the legal aid provisions will have a transformative effect, quite clearly, because no longer will families have to, go through intrusive funding processes or crowdfund or have to represent themselves. So but I mean, the culture, the change, the duty of candour, that at the moment, as I've already explained, we see exactly what families have spoken to you about, that adversarial nature, that victim blaming. Families describe their experiences time and time again as a battle. Now, these are grieving families who have experienced a death very often where the state has a duty of care. Something has gone catastrophically wrong, and yet they have to try and drag information out of those people who are responsible. That is just utterly unacceptable. So I do feel that if this bill actually lands on the ground and we have this duty of candour from top to bottom of organisations and people called to account if they continue to behave in the way you've described, then that will change the experience. The other thing to say is, there might be some suggestion that this is going to cause, problems within the coronial system, and that's our area of expertise. Now, if what this bill is trying to do is to stop that battle of trying to drag information out of people, there'll be proper disclosure, there'll be open honesty from the outset about where things have gone wrong. It should mean that processes are shorter, less traumatising, and can deliver the kind of answers not only that families need, but that we as society need to try and learn so that deaths aren't repeated.
Thank you. If I may sort of reply to that, those characteristics that you say were absolutely my experience, my family's experience of the inquest. Ofsted withholding information, providing redacted information that actually was so heavily redacted it required us to have a second pre-inquest review, so it extends the process, it adds to the expense. The idea, I know there's been some discussion that the legal funding might be delayed, and because it might lead to a bigger budget. I would say parity doesn't mean more money. It could mean, in the case of the Ofsted legal team, the coroner had to instruct them not to bring more than 7 members of their legal team into the court. And we had Reading Borough Council and the NHS Trust's legal team up against us. So actually, balancing might mean reducing the amount of money that public bodies spend. And if I may say one last thing, if this really is the last question, because I know we both want to say it, I think something else that absolutely needs to happen, whether as part of the Hillsborough law or as a separate thing, is that there must be some kind of national oversight mechanism to make sure that recommendations that come out of inquests and inquiries and so on actually happen, because, as I said, it's 2 years today since my sister's inquest began, and it speaks volumes that I am still here battling to try, frankly, just to prevent future deaths and to get Ofsted to do what they need to do to make their school inspection system safe. I shouldn't have to do that. There ought to be some independent, objective body that makes sure that those recommendations happen so it doesn't happen again.
Okay, we've got 2 minutes left. Maria Regal.
Thank you very much, Mr. Dowd. I mean, inquests are supposed to be inquisitorial. They're not supposed to be adversarial. Now, I know that, Deborah Coles, you deal with probably almost all adversarial inquests, probably the ones that you handle your organisation. The bill looks to ensure that public authorities' legal representation has to be necessary and proportionate. How do you see that impacting upon your daily sort of experience of the coronial system?
If I think if I'm answering the right question here, I think it should reduce the number of state lawyers that turn up to inquest and ensure a more equal playing field. I mean, I find it quite astonishing. There's two quick things I'd want to say here. Firstly, it is quite shameful that successive governments cannot tell us what the cost to the public purse is of state lawyers rocking up to inquests across the country. That information is not there, and it should be, and there is a commitment from this government to try and make sure that information is made available. But if we're talking about parity and if we're talking about proportionality, there needs to be proper monitoring of why it is a public body have sent a lawyer to an inquest process. It should be there to assist the uncovering of the truth, to assist the process. In my experience, too often, teams of lawyers from different state bodies turn up at the inquest, work together, or if they don't work together, they're trying to kind of pass the buck to each other. And the time at which you see them at their most kind of active and animated is at the point at which the coroner is going to decide questions that may be left to an inquest jury who can bring forward... inquest juries play a very vital role, I should just make the point here, at inquest, because they can report on narrative conclusions around systemic failings that they've heard through the evidence that's come out through the inquest. And you see these lawyers standing up, arguing with the coroner about what questions should be left to the jury, trying to minimise any criticism of their particular public body, and importantly try and persuade the coroner not to make a prevention of future death report, which of course can be so important in trying to stop these deaths from happening in the future. So hopefully we'll see a change in that kind of culture of just sending lawyers period to inquest.
I can see you're going to try and stop this, but
I'm sorry. I do apologise. That it's a pretty strict timetable, but I do appreciate you coming in today, and so it's a matter of sensitivity, and I'm trying to give as many people as the opportunity to express their views and ask the questions. So thank you very much for that, for your attendance, Professor Waters and Ms. Coles. Thank you very much.
Thank you.
Thank you.
Thank you.
We very much appreciate it.
Mr. Dowd.
Not an intervention, because we really need to move on, possibly. It just eats into the time available. If you wish to ask a question...
Very quickly, I was going to ask...
Is there a point of order?
A point of order. Is it possible that we can ask witnesses who might have something to add if they can write to you as chair?
Well, I think
do that anyway.
It's automatically done. So just let me chair the meeting, if you don't mind. I prefer if you allowed me to chair the meeting.